Hi, and welcome to the second episode of Season 2 of my vlog, Personal Injury Lawyer Tips. My name is Leroy Rudder. I'm a personal injury lawyer specializing in catastrophic impairment law. I'm also a published author of the LexisNexis Inc. book called Catastrophic Impairment Law in Canada, a director at Head Injury Rehabilitation Ontario, a co-chair of the Law Society of Ontario's annual Solo and Small Firm Conference, and the founder and owner of my law firm, Rudder Law Group. In this vlog, I'll be discussing a recent 2021 decision of the Ontario Court of Appeals outline of the test for admissibility of an expert's report into evidence and the remedies available to the court in situations where the expert's testimony exceeds the four corners of the report. Some of the remedies I'll be discussing are denying the expert the opportunity to present the evidence, permitting additional re-examination, providing correcting instruction to the jury, discharging the jury, and proceeding with a mistrial. So this tort action arose from a motor vehicle accident which occurred on November 9th, 2011. The respondent plaintiff, Mr. Peter St. Marthe, was riding his bicycle and was hit by the motor vehicle of the appellant defendant, Ms. Leslie J. O'Connor. Mr. Marthe claimed to have suffered soft tissue injuries, which rendered him functionally incapable of continuing to work in the construction industry. As a result, he returned to school to be retrained in order to enable him to pursue a more sedentary vocation. 3 years after the accident, November 9th, 2014, orthopedic surgeon Dr. Musette assessed Mr. Marthe, further to the request of his first-party accident benefits insurer. In Dr. Musette's report, he stated, amongst other things, the following, quote, "In my opinion, his ongoing right upper back pain is related to his previous injury. The symptoms impair his ability to use his back and right arm with any strenuous activity. This has resulted in the inability to perform expected duties at work without experiencing pain and discomfort," end quote. Following the assessment, Dr. Musette concluded that Mr. Marthe sustained an impairment as a direct result of the motor vehicle accident, and that the proposed OCF 18 treatment and assessment plan was reasonable and necessary, and that he still requires additional treatment. However, prior to the assessment, Dr. Musette was only provided with forms from the insurer, but was not provided with any medical documentation. Furthermore, Dr. Musette did not see Mr. Marthe or review any medical reports after that date. Fast track 4 years later, and the case went to a jury trial, where liability was conceded. The only two issues for trial was whether the tort action should be dismissed pursuant to Section 4 of the Limitations Act, and what general non-pecuniary damages and pecuniary damages, if any, should be awarded to Mr. Marthe. So at trial, the lawyer representing the respondent plaintiff, Mr. Marthe, called Dr. Musette as a non-party expert and included his accident benefits report in their joint document brief. During the examination in chief of Dr. Musette, he testified about his findings and the conclusion in his report that the treatment was reasonable and necessary. On cross-examination, the lawyer representing the appellant defendant, Ms. O'Connor, asked a series of questions and got Dr. Musette to state on the record that Mr. Marthe's muscle spasm was not disabling and would prevent him from working. The respondent's counsel objected to the appellant's counsel's attempts to solicit opinion evidence from Dr. Musette in regards to Mr. Marthe's ability to return to physically taxing work in construction. The trial judge addressed the objection, then decided to allow the respondent's counsel to re-examine Dr. Musette. On re-examination, the respondent's counsel tried to mitigate the damage stemming from Dr. Musette, a non-party expert, providing opinion evidence like a litigation expert, but to no avail. So the respondent's counsel brought a motion for an order to discharge the jury on the basis that, notwithstanding his right to re-examine, the cross-examination was seriously unfair, unexpected, and elicited opinion evidence from Dr. Musette on matters that existed outside of the four corners of his report, which irreparably damaged the primary claim that Mr. Marthe was no longer able to work in construction. The trial judge agreed and issued an order discharging the jury. And at the conclusion of the trial, he awarded the respondent $205,622.23 in damages, plus interest, costs, and disbursements. The appellant defendant appealed the trial judge's decision to the Court of Appeal for Ontario. So the two issues on appeal were whether the trial judge erred in ruling that counsel for the appellant improperly elicited inadmissible opinion evidence from Dr. Musette with respect to the respondent's functional capacity to work in construction, and whether the trial judge erred in discharging the jury. The appellant's counsel, the lawyer representing the defendant at-fault driver, argued that a lawyer is awarded wide latitude in conducting cross-examination, and this should not change just because a witness, such as Dr. Musette, is a non-party expert. If Dr. Musette's opinion exceeded the bounds of his accident benefits assessment, then a corrective instruction to the jury should have sufficed. Lastly, they argued the right to trial by jury is a substantive right, which should not be lightly interfered with, and there was no basis in this case to discharge the jury. On these bases, the appellant's counsel sought a new trial. The respondent's counsel, the lawyer representing the plaintiff cyclist, Mr. Marthe, argued that the question which asked Dr. Musette about Mr. Marthe's functional capacity to work in construction was improper. They argued that it, 1, went beyond the scope of admissible opinion evidence of a non-party expert, as the opinion was not formed or expressed during his involvement with the respondent and it was not contained in his report. 2, it elicited opinion evidence that had not previously been disclosed and amounted to trial by ambush. And 3, its probative value was outweighed by its prejudicial effect, and as such, it was not admissible. Lastly, they argued that the trial judge's discretionary decision to discharge a jury warrants appellate deference. The trial judge witnessed the impact of Dr. Musette's oral evidence and weighed the effect of cautioning the jury about the conduct of the appellant's trial counsel. On these bases, the respondent's counsel argued that the appeal should be dismissed. So the first issue was whether the trial judge erred in ruling that counsel for the appellant improperly elicited inadmissible opinion evidence from Dr. Musette. The Court of Appeal for Ontario addressed this issue by first reviewing the limits placed on non-party experts in giving opinion evidence, and then by applying the legal principles to the case. So what is the law of expert testimony? Well, in a civil proceeding, any expert retained to testify in a proceeding shall prepare an expert report to be shared with all of the parties in the action prior to the trial. This mandatory requirement is set out in Rule 53.03 of the Rules of Civil Procedure. These kinds of experts are referred to as litigation experts. The litigation expert's report would include an outline of his or her opinion and anticipated testimony. This expert report essentially sets out the limits on the expert testimony or opinion evidence that he or she may give at trial, and ensures that all parties have proper notice of the roadmap for the opinion evidence that will ultimately be provided. The litigation's expert report shall also include an acknowledgement of the expert's duty. In order to understand litigation experts better, it helps to distinguish them from non-party experts. In a case entitled Westerhoff and G. Estate, the Ontario Court of Appeal defined a non-party expert as follows, quote, a witness of special skill, knowledge, training, or experience who has not been engaged by or on behalf of a party to the litigation, end quote. It's important to remember that non-party experts are subject to different rules than litigation experts. In the case at bar, a non-party medical expert such as Dr. Musette, who has special skills, knowledge, training, or experience, may give opinion evidence for the truth of its content, provided that 1, his or her opinion is given as part of the exercise of his or her skill and knowledge while observing or participating in the events at issue, or 2, the opinion is not a complex vocational opinion requiring highly specialized expertise, and 3, it was disclosed to the opposing party. You typically see non-party expert opinions contained within clinical notes and records, or reports prepared for the purpose of consultation and treatment. Unlike a litigation expert, a non-party expert need not provide a Rule 53.03 expert report, where the opinion is based on his or her observation of or participation in the events at issue, and the opinion was formed as part of the exercise of skill, knowledge, training, and experience while observing or participating in the events. One of the reasons why the aforementioned requirement to provide a Rule 53.03 expert report does not typically apply to non-party experts is that disclosure problems do not exist in relation to the opinions of non-party experts requiring that they comply with Rule 53.03. Non-party experts, such as Dr. Musette in the case at bar, generally prepare their documents to summarize their opinions contemporaneously with their involvement in the events. These summaries, or the non-party experts' notes and records, can be obtained through the discovery process. However, in situations where the opinion evidence extends beyond the expert's observation of or participation in the events, and the opinion was not formed while observing the events, then the expert shall comply with the requirements set out in Rule 53.03 in regards to the portion of the opinion that exceeds these limits. Rule 53.03 provides that experts shall include the instructions given, a summary of the opinion, and the reasons for the opinion, among other requirements. Problems inevitably emerge when a non-party expert discloses his or her opinion only on the eve of or during the trial. As such, it is not an error for a trial judge, as in the case at bar, to take steps to prevent a non-party expert from giving opinion evidence that goes beyond the expert's observations and comments in the original report, if the opinion was not disclosed well in advance of trial. In regards to the admission of expert evidence at a trial, the Supreme Court of Canada established a two-part framework in a case called White, Burgess, Langeal, Inman, and Abbott and Halliburton Company. The trial judge must first assess whether the opinion evidence of the expert witness meets the threshold requirements of admissibility, which are 1. Relevance, 2. Necessity, 3. Absence of an exclusionary rule, and 4. Whether it has been provided by a properly qualified expert. If it does, then the trial judge will proceed to engage in a discretionary analysis to determine if its probative value outweighs its prejudicial effect. This is a part of the gatekeeper role that the judge plays at a trial, where the court may exclude evidence from a non-party expert if it does not meet the test of admissibility. In the case at bar, the evidence of Dr. Musette, a non-party expert, was limited to his opinion based on the skill and knowledge he exercised while observing the respondent during his one and only assessment of the respondent back in 2014, which was 4 years prior to the trial. Dr. Musette was not asked prior to his cross-examination to assess Mr. Marthe's ability to return to work. Plus, there weren't any notes or records of any kind, or any medical opinion being sought or offered at any time prior to the trial. However, during the appellate counsel's cross-examination, he sought and Dr. Musette gave opinion evidence for the first time concerning Mr. Marthe's muscle spasm condition not being disabling enough to prevent him from working in construction. Since Dr. Musette's opinion evidence went beyond the scope of his 2014 assessment and observation, the trial judge had the option to require Dr. Musette, a non-party expert, to comply with Rule 53.03 of the Rules of Civil Procedure in regards to the portion of his opinion extending beyond the scope of his role. But because there was no indication prior to Dr. Musette's cross-examination that this medical opinion would be solicited by him, he couldn't be ordered to comply with Rule 53.03 in regards to the portion of his opinion evidence that extended beyond the limits of his role as a non-party expert. Plus, this opinion evidence was elicited in front of a jury. The Court of Appeal for Ontario concluded that Dr. Musette's opinion evidence concerning Mr. Marthe's ability to return to work was not probative Because unlike other litigation experts who provide opinion evidence at a trial, it was not based on a current assessment of Mr. Marthe's accident-related impairments. Again, Mr. Musette assessed Mr. Marthe 4 years prior to the trial, didn't review his medical records. The Court of Appeal for Ontario concluded that Dr. Musette's opinion evidence was very prejudicial because it addressed the central issue at the trial concerning Mr. Marthe's past and future income loss, which was ultimately contingent on the jury's assessment of his disability and ability to work in construction, and as such went beyond the scope of his 2014 assessment. The Court of Appeal for Ontario also factored into its analysis the fact that the trial judge also determined that Dr. Musette was an impressive witness and was perceived as a neutral and impartial expert as opposed to a litigation expert who was retained and paid by a lawyer. So the Court of Appeal for Ontario ultimately concluded that the prejudicial effect of Dr. Musette's evidence on Mr. Marthe's employability and disability exceeded its probative value, and as a result, it did not meet the White-Burgess test for admissibility. As such, the trial judge appropriately determined that the cross-examination was improper. So the second issue that the Court of Appeal for Ontario addressed was whether the trial judge erred in deciding to discharge the jury. In addressing this second issue, it first reviewed the law regarding trial judges' exercise of discretion to discharge a jury, and then applied the legal principles to the facts of the case. So what is the law on discharging a jury? Well, the right to a jury trial in Ontario is a substantive right. So after a trial judge decides that a particular reference before a jury is prejudicial, like in the case at bar, the trial judge must then determine whether the prejudice is so severe that specific instructions cannot dispel that prejudice. The Court of Appeal for Ontario stated that a jury should only be discharged if the prejudice cannot be cured, because in most cases the trial judge will be able to fashion a remedy short of discharging the jury. Further to jurisprudence in Ontario, discharging a jury is considered a drastic remedy. However, the Court of Appeal for Ontario made it clear that a trial judge's decision to discharge a jury is a discretionary decision that will not be interfered with on appeal unless it, quote, was exercised arbitrarily or capriciously or was based upon a wrong or inapplicable principle of law, end quote. The Court of Appeal for Ontario concluded that the trial judge in the case at bar articulated clear and cogent reasons for discharging the jury. The trial judge held that, quote, trial fairness dictates that the jury be discharged and the trial continue before me alone, end quote, and concluded that Dr. Musette's opinion evidence could have a, quote, serious adverse impact, end quote, on the case. The Court of Appeal for Ontario also concluded that the trial judge was in the best position to assess the potential effect of Dr. Musette's testimony on members of the jury in respect of Mr. Marthe's claim for past and future income loss. Lastly, the Court of Appeal for Ontario stated that policy concerns about the importance of giving notice of evidence to be called, the avoidance of trial by ambush, which was articulated in the case entitled Alt in Canada, Attorney General, were also present in this case. As such, the Court of Appeal for Ontario saw no basis to interfere with the trial judge's discretionary decision to discharge the jury. I hope you found this information valuable. If you want more information, then please read my blog of the same name called The Test for Admissibility of an Expert's Report and Remedies for Exceeding the Four Corners of a Report. In my blog, I take a deep dive into the Ontario Court of Appeal's outline of the test for admissibility of an expert's report into evidence and the remedies available to the court in situations where the expert's testimony exceeds the four corners of the report. I also provide links to other blogs such as what is the cause of action for a negligence action in tort, and what damage awards do I get from a successful tort action, which provide additional information that you'll find helpful. My website is your one-stop source for answers to all of your legal questions concerning tort law, personal injury law, and catastrophic impairment law. If you want to book a free consultation with me, then please visit my webpage at rudderlawgroup.ca and click on the free consultation button at the top of the page. Let us be your rudder that steers your legal ship in the right direction. Please subscribe to my YouTube channel and click the like button if you found the content valuable. There you'll also find other vlogs with valuable content on tort law, personal injury law, and catastrophic impairment law. Thank you, and I'll see you soon in episode 3 of season 2 of Personal Injury Lawyer Tips, where I'll bring you more useful legal information.